Welcome, everybody. Welcome, ladies and gentlemen. I'm very pleased to welcome you on behalf of the London Shipping Law Centre's founder and chairman, Dr. Aleka Shepherd, to this hybrid event on BIMCO's new infectious or contagious diseases clause for time charters. My name is Nicola Cox. I started my career as a chancery barrister, that's landlord and tenant mortgages, nothing to do with shipping, in 1990. And I joined West of England P&I Club in 1994, and I head up the West of England's Defence Claims Department. I'm also a council member of the London Shipping Law Centre and a member of the Centre's Education and Events Committee, and was one of BIMCO's working group members who drafted both the 2015 clause and then the 2022 clause, which was published almost a month ago at the end of June now. I'd also like to thank the IDRC for providing the venue and these technical facilities for us and hosting the event in association with the London Shipping Law Centre. And I would also like to thank 36 Stone Chambers for kindly hosting the drinks reception afterwards. And I'm sure that in around an hour and a half's time, we'll all be having a glass of wine or two, thanks to 36 Stone Chambers' generosity. It's also great to have Nina Sturman here. She was the head of the working group. Natalia was the chairman of the working group, which reviewed the infectious or contagious diseases clause. So Nina is a German qualified lawyer, and before joining BIMCO in 2019, she worked at Aldendorf Carriers, where she was in charge of their legal transactions. So I'll hand over now to Nina.
So, hello everyone, I hope you can hear me. So we start now with the first slide. So good afternoon, everyone. We have a great lineup of panelists today, and I'm very much looking forward to our seminar and webinar tonight, where we will discuss our new or revised BIMCO infectious or contagious diseases clause for time charter parties 2022, and whether it will provide contractual immunity against future diseases, epidemics, and pandemics. We will have a discussion later today where we will go through the clause and we will all introduce our different aspects on the clause. So before we start, for the people who are watching this online, please post your questions in the Q&A and then we will get to them at the end of this discussion. So now the first slide. Good. So I actually don't start with the clause, because when we prepared this seminar, I got a lot of questions from people who asked me, how do I actually get on a BIMCO subcommittee and how do you do your work? And I think this is something where the industry is really interested in and they really look for some guidance on this. So, and I think a lot of people would like to be on our groups and it doesn't seem to be really transparent. So first of all, we develop our BIMCO clauses on our own with the Secretariat, but we cannot do it alone, so we are looking for the help of volunteers. And they will help us then with their knowledge and experience. Together with these people, we set up what we call a working group or a subcommittee. And you can see here two representatives of this group. This is Nicola and Natalia, and they are like really typical for what we have. Natalia is working in an operator, so she's in the middle. Like she is doing chartering ships in and also then like having voyage charter parties out. And Nicola is working in a P&I club in charge of the FD&D insurance. These are the people we actually need when we establish a subcommittee. On top, we also have charters representatives, because it is important for us that the clauses are accepted in the industry. If we don't achieve to develop clauses that are also acceptable to charters, at the end of the day, they will not be used. And then we don't provide any help for the industry. So this is why we have then a group which is then equally balanced. And we also involve brokers in this group so that we have more or less in this working group represented everyone who is part of a charter party. So this is how we do it. This is the people we have. And it's usually 6 to 8 people we put together. This is a rather small group, but if we have tried with bigger groups, and then it's really difficult to find consensus. So then how do we find these individuals? First of all, we look for certain areas. We look for the industry we need to have. We also look for the experience, and we also try to cover a wide global area, so that we have representatives from Asia, from Europe, and often from Asia, and there's from America. So it's for us really helpful that we can do Teams meetings, because then you can just the people don't have to travel so much, and we also find people who are really commercial and have commercial responsibility. And that's also really important for us, that we work with commercial people, because we need the practical input. Our clauses are not made for lawyers. Our clauses are made for the ordinary operator and the ordinary person sitting in the chartering department. So that is really important, that the clauses are easy to understand. So it's we have also, when you see the group, we have, I don't know, when you see the paper you have in front of you, you can see that the people who were in the drafting group for the IRCD clause have a very practical and commercial background, and we didn't involve so many lawyers. The only one who was in the beginning a lawyer was Nicola. And this is, and Philippa, but she then changed jobs and went elsewhere. And this is for us, we use these P&I representatives or lawyers to make sure that the contract has the right, or clause has the right belt and braces and is legally sound. But as often in an in-house shipping environment, you see that the operators and the charters come with their ideas, and the lawyers ensure that it's actually working well. So that is how we are doing this. So then if you look at the 4 objectives we have to achieve when we are developing contracts and clauses, the first one is it has to be a compromise. The second one is we have to provide for clarity. The third one is consistency, and the last one is certainty. And this is what we have this in mind when we choose the individuals then, because we have to find people who are able to make a compromise in our contract development meetings, because the compromise is so important to achieve the balance. If we don't have a balance clause, it will not be used. That's the first objective. Then the second one is that the people must have really high experience with the subject we are working on. And they also must have experience with using the BIMCO contracts and clauses, because the clauses have to be clear, and they also have to be consistent with with the other stuff we are doing. And it has to be aligned. It has to look the same more or less, and it has to follow the same outlook. And then the third, legal certainty, we get by involving people like Nicola and other lawyers to make sure that there are no legal, hopefully, no pitfalls. So this is what we are doing. And we are getting these people we have a big group of volunteers who are contacting us, and we also get a lot of recommendations if we have a new project. But I've heard often that people would like to be on the group and don't know what to do to be part of a subcommittee. So if anyone is interested, just write to us. And then we can get have a dialogue and see whether there's any room for the people. So, and lastly, we at BIMCO believe that diversity is really important. So we also have a focus of involving women to make the shipping industry a bit more friendly for women. Okay, so now, this is the reason why we are actually here. This is what are the reasons for the revision of the existing IRCD clauses. So we have not drafted a new clause. We have what we have done, our project is the revision of the existing clauses. We had both the clauses were drafted in 2015, and they were based on the situation we had during the Ebola outbreak. In 2015, we developed a time charter party version and a void charter party version. And you will all see, or I hope you have noted, that this time we only have a version for time charter parties. This is quite a new thing we have in BIMCO, and we will come to it later and explain why it's only a time charter version and why there is no void charter version. So the reason for revision of this clause was the feedback we got relatively shortly after the outbreak of the corona pandemic. And we got a lot of feedback that the clauses which were drafted in 2015 didn't really work with the pandemic. And this is because the clauses are based on an epidemic. and an epidemic and a pandemic are really, really different. We have, in 2015, the clauses were developed because the industry needed something to deal with, or like contractual tools to deal with the Ebola outbreak in Africa. But Ebola and other epidemics they have a significant lethality, so that the crew in that moment refused to call these ports. And for this situation, then back in 2015, it was considered the right thing to give the ship owners the right to refuse to call that port. But that has shown not to be suitable for the COVID-19 pandemic. And we have received feedback that the 2015 clauses were actually of little help during the pandemic because of the significant differences we have seen between a pandemic and an epidemic. The distinction between Ebola and COVID-19, so between an epidemic and a pandemic, was in the great majority of the cases, COVID-19 is actually not life-threatening other than Ebola. And trade continued in situations even when there was an outbreak, because the ship owners had like certain precautions. They had masks, they had like equipment, whatever. And this scenario that the owner can actually do something to prevent the infection of the crew was not covered by the previous clauses. And when you look, I hope you have seen the old clauses before, there's a definition of disease that worked very well for Ebola and other like very dangerous diseases, but for COVID, it created really great uncertainty. We were faced a lot with questions what in the beginning of the outbreak, but also throughout, is COVID seriously harmful to humans? It's still something that it's not really that clear. Another main difference between an epidemic and a pandemic is the impact the pandemic has. What we have seen with COVID is that it actually impacts the society because workers were quarantined or sick and normal life of ordinary people was disrupted. We saw that ports were closed because there were no workers. Ships were not allowed to berth to avoid infection of the population. Under the pandemic, we have seen that the ship actually is considered the risk by countries. We have seen that often in Asia, whereas in an epidemic, it's the other way around, that the crew and the ship doesn't want to go to a certain area because they are afraid of an infection. And this angle that the ship is considered as the risk was not covered by the previous clauses. Then there was a lot of discussions on the meaning of and definition of affected area. In the previous clauses that worked very well for an epidemic because that's a local outbreak, but for a pandemic, it's not workable because the entire world was more or less affected. So it was really difficult to get the right scope of the clause. And you can see that we went from a very local disease to something that was suddenly all over the world. Then the previous risk allocation mechanism, which we had for the epidemic, is also not suitable for the pandemic. The 2015 clauses has more or less one contractual remedy. That is, the charters have the obligation to give alternative orders within 48 hours if there's an outbreak. And if they fail to give these orders, the charters can the owners can just discharge the cargo. This is not, we have heard a lot that this is not acceptable to charters because they have other obligations under the sales contract or other voyage charter parties. So the clauses were actually not that accepted in the market. And when you had this situation that there was a disease, it was not really operable because the owners could not just discharge the cargo. It's not that easy. You cannot just throw it off board. So this is also something we had to keep in mind when we revise the clauses, like what is actually a practicable solution? Because the clauses we have that sometimes they are like a bit forgotten over time, and then suddenly something happens and they have to operate. And this is then time has passed or something has changed and it doesn't work in the current environment anymore. So this is what we have seen with our clauses. And then one of the main issues we have seen it with COVID, which is so different from an epidemic, is the trade continued. there was no any real stop worldwide. We have the global trade was not disrupted as such. It was just at a very, very different pace. We had a lot of disruptions. We had a lot of like short disruptions. We had a lot of delays, but it was maybe for a very short time, but that changed then afterwards. The ships called the ports, but they had to wait for a very long time. And this was also not allocated or not dealt with in our previous clauses. And that has shown to be the main issue with COVID. So this is something we have addressed in the new clause, and Natalia and I will speak about it later. So then the clause we have drafted, the new one, was drafted during COVID pandemic. And we have learned from the experience, and that was the first pandemic we all have seen, and this is what it was based on, but it's actually not a COVID-19 clause. And this is really important to note, because at BIMCO, we develop clauses that should have a lifespan of 10 years. And unfortunately, when we do some research or when we read articles from the scientists, there seems to be a very, very high risk that we will in our lifetime face more pandemics. One of the reasons is climate change, because, I don't know, ticks and insects, they have different response to the war, like the change in the climate. So it's more and more likely that that more pandemics will come. And I was at a UN conference lately, and they are just waiting for the next one. And this is really scary to hear. So this is why we have to develop something that is also working for the next unknown pandemic. So when you look at the clause, it's really, really general. And we didn't develop a clause that's too prescriptive or like COVID-based, because then we would have created another situation where it's just suitable. The clause would be just suitable for scenario A. But this is not what we want, because we have to look into the future. So then our main work was, after we found out that the clauses are not really working for a pandemic, we had to find out how we can we add this pandemic bit to the existing clauses. And then we try to find out what is actually the main issue the industry is facing, and what is the main impact of COVID. And then we had a lot of discussions, but everyone immediately said it's the delays. Ships have to wait, it takes forever, it's a lot of liability, who bears the cost, all these things. And we focused then on that, because we thought this is the missing element, and this is what the commercial people are interested about, and this is what we had to deal with to make the clauses acceptable to everyone. Then the second one, and we will talk about this later, the second one is the human factor on the crew. So that a lot of people were concerned, and crew members were concerned about their health, but this is also still dealt with in the clause. So there is, like, as last resort, the right to refuse to call a port. So this is the background why we developed the clause. And now I'm having a little chat with Natalia. She is, as we said, senior chartering manager at Norton, and she chaired the BIMCO working group. And we will now explain to you, she has this very commercial background, and we are talking about the situation how they have faced and what was going on. So what was the main problems you have seen during COVID?
Thank you, Nina. So in a room full of lawyers, this is kind of a big no-no to say, but on the chartering side, we experienced something that we call fix and forget. So when everybody came in 2015 and fixed this wonderful BIMCO IOCD 2015 clause, they left it in the charter parties and forgot about it. Roll around COVID, and it was absolute mayhem. It was sheer panic. I think every single one of us looked at each other and all of a sudden overnight had to kind of become our own lawyers, because not even our own lawyers could manage the onslaught of questions that started coming. It wasn't just that the clause itself was commercially impractical. It was just not even what we would call back-to-back with any of the current voyage charter parties that we had with our massive COA partners, or just even one voyage trip. So we found ourselves, even as operators or owners, sitting in the middle where owners would refuse to call a port where they had cargo, they were fully laden, or they were in the middle of discharge and they would just automatically leave the port without telling us. And charterers would be kicking and screaming because of course it's not back to back and it's not something that is in any way, shape or form the owner's onus to do so. But of course we have to understand that it's up to crew safety. I think as a result of this sheer panic, there was a lot of the confusion with the definitions. As Nina mentioned, disease, COVID doesn't fall under that category. Affected areas, the entire world at some point very quickly became an affected area. So yeah, there were pockets where I remember Italy, Spain, potential port closures. There was mass fear. And as a result of mass fear, a lot of charterers came to us and declared force majeure, which, as you can imagine, as an operator or even as an owner, you sit there wondering, is this even applicable as a force majeure? Some force majeure clauses only state epidemic. But of course, if there are port closures and logistics issues, charters can try and finagle that angle. So I think in general, it was just a sheer amount of confusion that was in general not covered by the 2015 clause at all, and very unrealistic in the practical way that how in chartering we viewed it both at Norden and globally. I think very quickly we came up with ways of needing to work to figure out a way around that clause. So we would take charter parties and strip them of the 2015 clause altogether and just create hybrid clauses, which I'm sure our lawyers loved because that made it all the more difficult for them to figure things out. But we had no choice.
So this input was really valuable for us because we needed to see all the scenarios and we needed to understand like the panic, and then we had to just take a step back from it when drafting the clauses. But this is what Natalia described as like the main parameters we have in the clause, and we have addressed them in the clause. So how have we done this?
I think one thing that Nina and all of us on the subcommittee wanted to highlight, and we keep highlighting, is the commercial practicality of this clause. How does it actually happen on the ground? And I think this is how we really viewed this. We debated for about 11 months, almost a year, about how exactly does this happen in practice. So we really, really needed to work around the concept of reconstructing and adding these new definitions. So as you see, we took away the concept of affected areas because it's not just going to be an epidemic going forward. I mean, we have monkeypox as a great example. Not that, hopefully, knock on wood, that's not shipping related yet. But we really wanted to try and have these concepts that were applicable. Disease, slightly more broad, but an umbrella that covers both epidemics and pandemics. The idea of preventative measure, giving the burden of responsibility to the owners, but also the ability for them to be able to stop over in Jib or en route in the Panama Canal and pick up preventative measures. But preventative measures don't just stop at PPE. They also include the master's right to refuse access to the ship, because something that we noticed quite often in COVID was that armed guards exposed the crew, stevedores exposed the crew. And this is something that, of course, the vessel should have the right to reject. That's safety to the crew. But it should not stop the trade. It should not prevent the trade from happening. That's something that can be commercially resolved through a discussion. That's practically how it always works. We discuss. Another thing that was very clearly stipulated in this one was an on-off hire concept for the quarantine. This was non-existent in the previous clause. Some people believe that it would fall under the concept of the general quarantine clause in the time charter party or in the voyage party, but we did not see that happen in practicality. It became a point where people would try and get more money on the hire and so on and so forth. So we really wanted to be very crystal clear about what is an owner's responsibility and where does the charter responsibility lie. And I think having both the input of Vale, Oldendorf, and several other members of the society, of course, also Nicola and Nina, it was very helpful for us to see how exactly to allocate these on-off hire quarantine risks. The idea of the risk exposure notice we'll come to discuss a little bit later. This is a very new concept. The idea of a risk exposure notice, actually, we created this word, but in practice, this is exactly what happens. We can use piracy as a great example. If we are to sail into a region as an owner, operator, or we have a ship on time charter for us, and the owner fears that the piracy situation has escalated, they can't just outright refuse it. They need to have evidence. And that, therefore, this risk exposure notice is an evidence-based burden that the owners have to provide, but also that the charterers need to adhere to. The risk exposure notice only comes if owners believe that the preventative measures that they're going to be taking do not suffice. This is how it happens very much in practice. It is a step-by-step play. It happens quickly or slowly, depending on the duration of the trade, but this is actually how it happens. And of course, the number one priority is that the crew and the vessel are always safe, but that the trade will continue one way or another, and it will be commercially resolved.
Yeah, this is something what Natalia has just pointed out, the allocation of liability. We have discussed that in great detail, and we have run different scenarios like 50-50% share. How can we find out who is liable? Is there something like what should be the basis of it? And we thought about, I think like 2 months about it, and we thought whatever we do and whatever scenario we come up with, whatever mechanism, we just make it more complicated. Because with these diseases, you cannot just, it's not as easy as in other cases, because how on earth can you finally establish who bought something on board? Who was the reason for the infection? So this is why we really made it this clear cut that we said, okay, it's the charterers because they direct the ship. It's the ship is in their control. And unless it's something from previous trading, then, or the owners really caused it, then it sits, the loss sits and the liability sits with the charterers. And that was also, we had really strong chartering people on the subcommittee, and they really fought for their rights, and they accepted this. So this is why we hope and we think that the clauses will also be accepted by charterers, because we had a bit in this working group, we had a bit these discussions you have in real-time negotiations. So this is we tried, I hope we did a good job on that one. So the next one, good. Then you can see when you look at the clauses and compare it to the previous one, the new clause, it's really different. And Natalia has actually highlighted why. And now we really hope that the new clause will have greater acceptance, because we got feedback that especially the voyage charter party clause was not accepted at all. So why do you think that the new one will be better?
So I think that as a result of going at this in a very commercial way, we were able to understand that there are certain things that in every clause under the sun, we as chartering managers will trade it. Our job is to trade, otherwise we wouldn't have a job. So we went at it on that basis, that the trade will continue and that things will always be traded out, because that's normal. But we want the general concept of the clause to be accepted, unlike the 2015 one, which was completely scrapped. So as you can see in part of the clause, there is even a place with regards to cost that is left blank, because that's something that we do negotiate money. That's part of shipping. It happens in the piracy clause, and it happens in all sort of other clauses. That's how we do things. So the concept of liability, the concept of cost, is an open-ended subject over here, which for some lawyers may sit uncomfortably, but that's how it happens practically. So I think that that's one really key thing that we need to highlight here. Another thing that we came quite head to head on during the 2015 discussions was this concept of time pressure, because we don't have that on voyage charter parties. We don't have really, the 2015 clause did try to stipulate it, but as Nina mentioned, none of our voyage charters accepted this. 48 hours to issue alternative voyage orders. We had charters, Vale, for example, who said that this is impossible. It's physically impossible to put pressure on shippers and receivers to do something like this, because they may not be able to. So you may end up loading the cargo and sailing, and thereafter receive alternative orders, or be proceeding to a port and potentially have to anchor and wait a little bit. But it's one of those things that pigeonholing a charter into the concept of 48 hours will end up becoming null and void. So instead, what we decided to do was that we said the concept of reasonable time, there is obviously law case for the concept of reasonable, but also that while the vessel waits, she's on hire. This means that there is pressure commercially on the charterers. There is no charter in the world that wants to sit there paying higher and having the vessel not do anything. So there's an onus of both charters and owners to work this out commercially. And this is how we do it on the ground. I feel a bit like a broken record, but this is very much how it happens on the ground. And I think that this, not only the clear allocation of quarantine responsibilities, this concept of a lack of set time, but more of a discussion, a commercial discussion, and also the idea that we have this risk exposure notice, as we explained before. I think all of these things combined actually really will help provide that this clause is incorporated into charter parties, is discussed, is used and viewed more reasonably than the 2015 clause.
Yeah, on the reasonable time for giving alternative orders, we have to present all our clauses in our documentary committee. And we got a bit of feedback back then. What is reasonable? Shall there be no cap on it? And because if you look at it, it's not so super owner friendly, but then we thought this only applies in situation when there's cargo on board and the cargo has a value and the charters have an obligation to do something with the cargo. So it would be really, really unlikely that the charters just walk away from the situation if we thought it's not possible at all. So we then also, we also took this different approach this time, that we said, we just leave this clause open to the commercial people to fix it and find a solution. And we don't frame the clause too much, because all like the framing we thought about would be limiting, because what works for bulk doesn't work for tankers, and what works for coal doesn't work for grain. So we thought whatever limit we put on would actually be too limiting. So then the next one, and that's the last one for like the two of us for today, is we have not developed a voyage charter party clause. And as I said before, that's the first time in our BIMCO existence that we don't have back-to-back clauses. And developing the voyage charter party clause, or what we tried, actually took, I don't know, 9 out of 11 months. So, and now we try to explain why there is no such clause.
So yeah, we weren't just being lazy and decided to push aside the voyage clause, but we did actually have a very wholehearted debate on the concept of whether or not this was applicable. We kind of came to the conclusion that at this point it would be very difficult to put in a voyage clause without hearing the reaction and feeling the reaction from the industry, because we would fall back into the same trap of the 2015 clauses, where we rolled out a TC clause that was incorporated, but the 2015 voyage clause in any single voyage charter party I read prior COVID never really had a 2015 voyage IOCD clause. And there was a reason for that. There was no charter in their right mind that was willing to accept that. So we really wanted to understand and gauge this reaction from the industry. We also had a couple of moments where we very much almost had a voyage clause. We were so close, so close. And then we would question whether or not this was acting against a force majeure clause in the CP or a quarantine clause in the CP, and specifically lay time clauses in the CP. This is a very, very dangerous thing to start tampering with in a voyage charter party. So we really wanted to have this discussion with the industry once this TC clause comes out and see how exactly do we want to frame this. Because another thing from experience on the ground, money talks when it comes to voyage, and most of these things can be practically solved through freight solutions. You can have lay time calculations that end up in lower or higher freight, demurrage concepts that kick in. And so most of the time, a lot of this can actually be covered that way. So for lack of a better word, we're going to sit back and wait.
Yeah, we also identified the scenarios when we could actually, when this clause would be helpful. And we thought it would be only at the very, very beginning of an outbreak, because this is the situation when no one took it into consideration. The charterers representatives, and we had big trading houses in the group, and we also asked for special feedback. They said, once you know there is a pandemic, dear owner, you accepted to call ABC port. So this is then compensated in the freight rate. And this is why it was really no room for them to accept it. And then it sounded also to us to be a fair solution, because waiting time and everything will go into the freight. So this is, and then at the beginning of an outbreak, it was really difficult to draft such a clause because we have then the interference with the force majeure thing, because it has to be something unforeseeable. And we have just in 2022 developed and published the BIMCO force majeure clause. So we also thought, and that also addresses pandemics and epidemics. So we thought there's actually no real gap to the industry when we have this situation. So I think then, thanks, Natalia, we are done. Then we go over, do you need the computer? Okay, so now we go over to Nicola. Nicola is working a lot with us because she has a great experience and also is really good in her field. So,
Well, we'll see what the audience thinks of the clause in shortly, won't we? Thank you, Nina and Natalia. So whilst we, hopefully that the worst effects of COVID or the serious, there's Omicron variants for COVID, but the serious effects of the disease to most of humanity is now not so severe. I think it's widely accepted, as Nina has said, that there is likely to be further pandemics caused by a mixture. You've got global warming, you've got intensive livestock farming, you've also got going into deforestation to virgin rainforests, all of which will expose humanity to new pathogens, which the immune system haven't yet come across. And I won't go into this link now because then I have to share the screen. It gets a bit complicated. But basically, I was showing one of the studies that's been done by the EU on the future likelihood of pandemics and where such pandemics are likely to stem from. So what I'm going to be talking about, three things mainly. Firstly, I'll give an outline of West of England's experience with COVID-related charter party disputes, so the FD&D disputes, and illustrating just one of our cases and why, in my view, in using that illustration, using the normal NYP clauses really doesn't do the job. We really do need a bespoke clause to deal with diseases and pandemics that will suit, that will apply to a range of circumstances. I'll also be talking about, although Nina and Natalia have done quite a lot already, with the risk of sounding like an estate agent, interesting features of the new clause, just going through it briefly, and also some of the alternative mechanisms we were discussing and why we didn't choose those. And then thirdly, on club cover, so during BIMCO's review and in the documentary committee, there was some concern raised about subclause D, which you'll see in the handout, is where the owners ask for new orders. So where bills of lading have been already issued, there's maybe cargo already on board, owners ask for new orders, will that prove a problem for club cover? And if so, is there anything that can be done about it? So those are the three main planks of what I will be talking about today. So I start with the defence, West of England's defence. So again, this is not the P&I quarantine experience, this is the defence charter party disputes. So generally in December, so 6 months ago, we had 157 COVID-related defence files, which is just under 10% of all our defence files that are open at any one time. And those were spread pretty evenly between both charter and owner members, and also between all our offices, so London, Greece, Singapore, and Hong Kong, but not in New York, but the other offices. Luckily, fortunately, for both of our members and the club, most were small, they didn't cost very much money, and they closed quite quickly. So as at December, only about 50% of the files remained open. And then looking now, July, we've still got 78. It's not quite the same 78. But again, most are very small, modest in cost, so less than, say, $5,000, $10,000 net to the club. We have got a handful of large ones within the pipeline. One's been reported, documents-only arbitration. We've also got one on an MOA, a sale and purchase of a ship, and also a couple which involve both defence and P&I. So you've got delay, and you've also got P&I quarantine costs that the owners want to pass down the charter party line. So that will be a mix of FD&D and P&I. And so, as I say, there is a real need for a bespoke clause, because without a bespoke diseases clause, the usual approach in a time charter say is the off-hire clause is one of the clauses mainly used under NYP clause 15. So you get in the event of loss of time from deficiency or default of officers or any other similar cause, and you may have with, without whatsoever. And if you have whatsoever, then that's against owners because it widens the pool of potential causes that may mean the vessel's off-hire, preventing the full working of the vessel, payment of hire shall cease. And the case that's very often quoted here is back in 1997, the Laconian Confidence on the off-hire clause. So there, it's sort of very much treated and it's trotted out, I think, in virtually all our cases on off-hire. But there, I mean, the facts had nothing to do with disease. In that situation, the vessel had actually was completed discharge at Chittagong. She'd loaded 100,000 tons of bagged rice, and there was just under 16 tons of bagged rice residues, rejected cargo left on board. And the Chittagong authorities didn't allow the vessel to sail with these 15.75 tons of cargo on board. And she was then waiting at Chittagong port for 18 days until the Chittagong authorities finally allowed the ship to sail, and I think they dumped the cargo overboard. So there, in that case, the arbitrators, so the question was, for those 18 days, was she on hire or off hire? In that case, the arbitrators found in the owner's favor, the ship was on hire. They say that the delay did not inevitably arise from the nature of the cargo damage, if there was damage, or for the cargo rejection, but the delay arose from the remarkable reaction by the local Chittagong authorities. Charter was appealed, but Mr. Justice Ricks, as he then was, upheld the arbitrator's decision, so he upheld it in owner's favor, and he said, as it says here, I would, however, observe there are two interrelated concepts. One is a typical off-hire clause does not cover an extraneous cause, and the other is that a vessel cannot be off-hire unless there's some defect or incapacity of or in the vessel which affects her working. And Mr. Justice Ricks observed that affects her working or full working the vessel doesn't just mean physical, it can also be legal, and it cannot, the incapacity doesn't have to relate to the vessel herself. It can be legal and physical, it can be internal to the vessel, or it can be external due to extraneous causes, for example. And here, in that case, he said, by reason of the interference of the authorities fulfills the requirements preventing the full working of the vessel, at least if the authorities' interference is not totally extraneous. So there's an emphasis on that. And again, he said what's any other cause does not cover an entirely extraneous cause. For example, the interference of authorities unjustified by the condition of the ship or cargo. So you get a case on off-hire and on-hire, which is trotted out in nearly every single one of our off-hire disputes, which has nothing to do with disease, and it's certainly also a very long time ago. The other clause that's often trotted out is the NYP clause 8, the employment clause. So again, the vessel basically will be under the orders of the employment of the charterers as regards employment and agency. And here, the case that comes out is the Bergesund in 1993. In that case, the tribunal held in, so here's another tank cleaning case. In this one, the vessel's en route to her load port. And then she arrived at the load port, the tanks weren't clean, and further time had to be spent. And the question was, in that time, whilst the vessel's holds tanks were being cleaned, was that on hire or off hire? So again, nothing to do with disease. Interestingly, there, the arbitrators found in favor of the charterers, saying that therefore the ship was off hire. The first instance court also upheld that, but the Court of Appeal, and there one of the barristers for owners there was Bernard Ricks QC, the person who was then a judge in the Laconian Confidence 4 years later. The Court of Appeal overturned and found it in favor of owners. So even though the ship wasn't ready, her tanks weren't clean, she was not off hire, she was on hire because the service required, the Court of Appeal held, was cleaning the tanks, and clearly the crew were cleaning the tanks. Therefore, she was on hire and time counted. So going sort of, as I say, most of our cases on off hire use these cases and these clauses in the NYP Charter. And going briefly through one West of England defence case, again, we've got the clause 15. There wasn't whatsoever. so it's in owners' favour. And there was also additional clause 45. So it deals a little bit with certifications and vaccinations. Officers and crew to comply with vaccination and sanitary regulations in all ports of call, and corresponding certificates to be available on board, enabling the vessel to obtain free pratique. And if requested, owners to provide charterers with copies of any certificates. And then it says any time lost and extra expenses resulting from the failure of that to be for owner's account. So on the facts of here, we got it in June 2020, so quite early on in the pandemic, still in the first half of 2020, no vaccinations available, no readily available even testing that was very reliable. And so she was delivered under charter in the end of June. End of July, she was waiting to discharge in China. And the statement of facts said, awaiting customs officer permission for discharging due to one crew fever, crew temperature 37.4 degrees, nucleic acid test had to be conducted as request. And there, the charterers, who are our members, claimed that those 2 days, 2.5 days between the 26th and 28th of July, therefore she was off hire because she was prevented from discharging. It's not a question of cleaning. It wasn't the crew was doing cleaning instead, like Bergesund. She was sitting there doing nothing, and that's why they claimed that the vessel was off hire. So here, charterers there, who was our members, said clearly the delay was linked to or due to the health of the crew on board. There's no allegation it was, for example, that any COVID had been brought on by charterers agents like a supercargo or a stevedore. And also, don't forget, it was the early on in 2020. Everyone's super worried and anxious. There were no vaccinations, hardly any testing. It was in China. And then also, as charterers said, there wasn't a BIMCO clause, which said it was very much perceived as owners' friendly clause. So if the BIMCO clause wasn't in a charter said, therefore, parties must have intended that if there was this type of delay linked to COVID or suspicion of COVID, it must have been intended that owners would bear that time, so it should be off hire. Owners, on the other hand, argued on the facts that the body temperature of 37.4 is within a normal range, not unwell, unable to perform his duties, and therefore it wasn't caused, any delay was not caused by the crew sickness, it was caused by the local authorities' reaction to the potential crew sickness, and therefore caused by the regulations of the port, and therefore owners said this should be down to charterers. So I don't know how everybody thinks here what you thought which way you think the tribunal might have decided. Hands up who thought they decided in our member charterers' favour. Who thought they decided in the owner's favour? Yeah, you're correct. So even though, and we tried to, and I think maybe this was a decision on documents, it wasn't in a hearing, and this was a decision made 12, 18 months after the facts. So by then we had vaccinations, we had testing, that initial uncertainty and anxiety was over. So even though you tried to say this on behalf of charterers, that don't, you're judging it now with hindsight. Bear in mind what it was like at the beginning of 2020 and in China, and at the early stage. And the tribunal referred to that in the award. We're mindful of the fact that these events occurred at a sensitive time after the outbreak of the pandemic in China. But then they went on, that does not in itself justify any decisions made by the authorities in the name of the pandemic. And they referred to 37.4 degrees. It's not a sort of temperature, it's a normal range of temperatures. And then they said that there was therefore no good reason for the actions of the quarantine officer, which we find to have been excessive, seemingly arbitrary and unjustified. So therefore they held that the delay was not due to this 37.4 degree temperature or COVID, whether it's actual potential, but all due to what in Laconian confidence was described as the extraneous cause, the port authorities' reaction to that fact. They also held tribunal that clause 45 doesn't assist, because, of course, in early 2020, there weren't any vaccinations. So the fact there was no vaccination certificates was neither here nor there. It was certainly no proof of a breach on the part of owners. And this was actually the published case. There's only been a couple of published cases that Ravi will talk about. This was number 6 of 22. So this is where the LMAA asks the parties after an award, if the case is of interest to the industry, they'll ask the parties if they object. And certainly we as a club encouraged our member to have it published so there's some guidance for the shipping community. So as I say, in my view, and I think it's, not unusual, off-hire provisions, the general clause 15, clause 8, employment clause, are really not suited to diseases. It really is quite a stretch talking about off-hire clause in the 1990s diseases. And it's like a translation from off-hire between the physical working of the vessel, which is what clause 15 says in the black and white print, from there to the condition of the crew on board, the health of the crew, and it might not even be the actual health, it could be suspected health of the crew or suspected abnormal health of the crew. It might not even be the actual health of the crew, it could be the Port Authority's reaction to the health of the crew. It might be the Port Authority's reaction to the vessel's history of suspected COVID on board the vessel. And it's stretching the words of clause 15 and the intention between preventing the full working of the vessel, I think, beyond what works in practice. And also that, for that reason, leads to huge uncertainty around this extent of owners' obligations both about whether it's going to be off-hire and on-hire, but also what are owners' obligations for seaworthiness. And that's why the clause puts in for the first time that owners have to have preventative measures. So you've got some positive obligation on owners, and you've got a bespoke clause that deals with time loss for disease, rather than talking about residues of bagged cargoes in Chittagong in 1994. So it deals much more specifically with the case at hand. And so dealing very quickly with sort of special features, because they've been dealt with quite a lot already very well by Nina and Natalia. We've got preventative measures. The first time it's been put into the clause. We've ditched the affected area concept, as it said. The concept which is for Ebola, the specific area geography doesn't really work necessarily for all diseases. We've got for the first time a specific split of time and cost. So it'll be for charterers account any delay and cost unless the burden will be on charterers to prove whether it's due to owners. Written exposure notice, as said, this is a new concept. I'm quite interested to see how this will work out in practice, and particularly vis-a-vis disclosure and arbitration. So where the owner has given a written exposure risk notice under little d, and then it's disputed later on, and it gets to an award 3 years later in arbitration, for example, will the arbitrators allow owners to produce evidence outside what was in their notice at the time, or will owners, as a matter of evidential law or substantive law, be restricted to what's put in their exposure risk notice? So that's quite an interesting concept. And the idea really was, as we said, is to make sure that owners don't abuse the clause. And also, I welcome it from a defence club, because I hope it'll reduce the amount of imagination, put it that way, or work or costs that are incurred after the event 3 years later to go back and trawl and try to find evidence that may or may not have existed at the time. So we'll see how that works. And again, the main thing is you're not relying on these clause 15 off-hire, which is completely unsuited to diseases or suspected diseases. And so query, I hope there'll be more certainty. There's always a danger when you have a new clause, it brings in new disputes, new legal fees, but equally I'm hoping that the clause itself, which is intended to be one for operators to work and fairly common sense and clear, I'm hoping it'll provide certainty in the majority of disputes. And just briefly, the last thing, as I said, during the documentary committee, there was some concern expressed about whether when an owner asks for new orders, so the risk has increased, will that prove a problem for club cover, where the bills of lading for the cargo on board have already been issued. And as with all, under the pooling agreements, all 13 clubs, or soon to be 12 clubs probably, there is an express exception for cargo cover, where there's been discharge of cargo at a port or place other than in accordance with the contract of carriage, unless such cargo is discharged with the consent in writing of the managers. So yes, prima facie, but there's two caveats to that. One, of course, owners' right to call for alternative orders only exist in limited circumstances. They have to prove, one, there's an increase in risks. They have to serve, they have to show that the risk can't be mitigated by their own preventative measures. And they also have to serve as a precondition, a trigger, the exposure risk notice. So it's not likely, and that's it's intended to be, fairly restricted circumstances where owners could serve this notice. And also the clause itself provides, in accordance with, I think, nearly all BIMCO's clauses, that this clause should be put into subcharters and bills of lading. And of course, if that same option is included as it's intended in the charters the bills of lading produced as a result, then that shouldn't constitute a breach of the contract of carriage. Therefore, the member should be within club cover, because under English law, at least, he has a right to ask for those orders. So it's not a deviation or a breach of the contract of carriage. It could be, of course, in reality, nothing's perfect, that although owners put that clause into their charter party, which says you shall also put charterers this clause into your subcharter and bills of lading, it may be the subcharters don't do that. And so in that situation where owners ask for new orders and she sails to Newport, discharges the cargo at a different port, it may be that the cargo receiver produces the claim against an owner as a carrier, that the member will be in breach, that the owner will be in breach of the club cover. But the owner would have a discretionary claim to the Class 1 committee. It's a majority decision, not a unanimous decision. And there is available what we call ship owners liability cover, but it's available for owners and charterers for an extra premium where you're delivering cargo, discharging cargo not in accordance with the bill of lading or on the front face of the bill of lading. You can purchase additional cover certainly from West of England, either in the market or under our in-house, as it were, liability cover. So that's just a brief canter, as I say, run through of our cases and why bespoke clause is needed, and any P&I issues for where owners ask for new orders. I'll now hand over to Ravi.
Thanks very much, Nicola. Thanks, ladies. And thank you, Aleka and Gerard, for the opportunity to speak at this event. I hope everyone here who's here in person can stay and join us for a drink afterwards. In my session, I'm going to deal with two things. Firstly, I'm going to look at some potential practical issues. And you'll have to forgive me when I say practical, I have my lawyer's hat on, so I mean in the context of a dispute. And secondly, I'm going to look at some COVID-19 decisions which we have already had to date. They don't relate to an IOCD type clause, but hopefully you'll find them of some general interest because they do give rise to the sorts of issues which we have been discussing already this evening. Looking then at the practical issues, and like I said, I'm looking at them primarily from the perspective of an arbitral tribunal having to adjudicate on a dispute. I've put up on this slide some wording from the 2015 clauses. I do think it's going to be the case that there will still be a runoff of some disputes with charters containing these provisions. They're not always there, as we've already heard, but they certainly are there sometimes. And you've heard my co-panelists speaking about the affected area. I've just put on this slide the definition in the 2015 clauses about what an affected area is. And you'll immediately see there are at least two issues with this wording. The first is, it refers to a risk of exposure, but there's no mention about the degree of risk which is necessary. And that obviously is going to be the sort of issue which can give rise to all sorts of disputes and a battle of evidence. The second issue, I think, is that there's no reference to whose judgment is relevant to deciding whether this is an affected area in any particular case or not. And in particular, is it a subjective or an objective test? If it's subjective, what might the limiting factors be? Is it purely good faith or does reasonableness come into it? Now, I can't answer those questions in the abstract because it's not immediately apparent from that wording. And so in every case, it would inevitably be a question of construing the charter as a whole against the factual matrix. But it does show you that there are problems with this wording. And as Nina and Nicola have already mentioned, this affected area concept might well work better with a localized outbreak or an epidemic. The complications I've just mentioned will no doubt be minimized, although not eliminated in that kind of context. But for a global pandemic, I think they really would come to the fore, and it shows you where wording of this type just isn't, in my view, going to work. As we know, the BIMCO committee has taken that view and moved away to a different type of wording. It's inevitably going to be an issue in any live arbitrations where this kind of wording is in place. The whole world is an affected area in the context of a pandemic. So what does this clause actually mean? And we will have some difficult questions in these runoff cases I've mentioned, but going forwards, of course, if the 2022 wording is adapted, this shouldn't be a problem. I've put on this slide some wording for you. This is from an actual case of mine. And it just shows you the ingenuity of parties trying to find an interim solution before the 2020 IOCD clause had been available. So the parties in this particular time charter had modified the definition of affected area, as you can see. So they referred to the World Health Organization declaring a public health emergency or equivalent. And they'd said it has to be a material risk of exposure. And I mean, I have to say, this is an improvement in practical terms on the 2015 wording. So hats off to whoever came up with this wording. I do think actually, and we don't know what the decision is going to be in this particular case. This is from a live arbitration I'm instructed on. But the use of material risk, combination of WHO declaration of public health emergency, that actually makes it a bit more workable in practice, I think. But nevertheless, problems do remain. Fundamentally, I think, and we've heard the commercial perspective from Natalia, but however you vary this type of provision, you're left with something which is still fairly pro-owner. And there are many charterers who just aren't going to be willing to sign up to something like this. And one of the things we have seen with the 2022 wording, I think this is pretty uncontroversial, is an attempt to achieve a much more balanced regime, which both owners and charterers can perhaps live with. Now, I've put on this slide some of the 2022 clause wording concepts. You've got these in your pack. And these phrases and definitions do, I think, alleviate many of the concerns I've been speaking about. From a commercial perspective, as I've mentioned already, this is a bit more balanced. And some of the areas of uncertainty as to degree of risk and whose judgment is to be considered do have some answers in this wording, I think. Where we see the exposure risk notice, meaning a written notice from owners to charterers of a risk of exposure that includes supporting evidence thereof, that makes quite clear that owners have to contemporaneously carry out an inquiry and support their written notice with evidence. That seems to me to import two things. Firstly, it's got to be something which owners do in good faith. But the reference to supporting evidence does, to my mind, indicate a degree of objectivity in the test. Because when an LMAA arbitral tribunal is looking at the events 18 months down the line, they will be looking to see what inquiries were made contemporaneously and what supporting evidence owners gave in relation to their exposure risk notice. That doesn't take away the uncertainty, but I do think it mitigates it a little bit because the parties know or have a better idea of what needs to be established contemporaneously in order to make this clause work as a matter of practice. And as I've said in this slide, I do think taking a step back and looking at this, a test of risk of exposure which cannot be avoided by the taking of preventative measures and the evidence-backed exposure risk notice, it does have the feel of being something which is more readily understood, quantifiable and demonstrable by objective evidence. And that, of course, is the sort of thing which arbitrators, I think, will find it a little bit easier to make a judgment on. No doubt there will still be difficult factual issues in particular cases, but it does make life easier for people who are picking these cases up in a dispute resolution context later, trying to see what happened at the time and who's in the right and who's in the wrong. So an improvement all round on all fronts, I think, from the dispute resolution lawyer's perspective. Moving then on to my second topic, I'm going to be looking at some COVID-19 decisions of interest. London Arbitration 6 of 22 is only there so that the list is comprehensive, but I'm not going to add anything to what Nicola has already said. But I'll look at the other three decisions. Arbitration 4 of 22 obviously is an LMAA decision, and the other two are High Court decisions. Let's then start with Tenke Fungurume. This is, as the names of the parties might give away, not a shipping case. It arose out of a mining contract in the Democratic Republic of Congo. And I'm just going to give you one part of the relevant chronology. There were quite a few things happening here, but what we are interested in for present purposes is that on the 4th of February 2021, the respondent sought a 2-month adjournment. The hearing was listed at that stage for the 1st to the 8th of March. And this was on the basis that leading counsel, it briefed, had become ill, succumbed to COVID-19. A decision was reached by the tribunal on the 9th of February. They issued a procedural order dismissing the application for an adjournment, and the merits hearing duly took place on the 1st to the 8th of March. Interestingly, there was some discussion in the introductory paragraph of Mrs. Justice Mulder's judgment about a dispute as to whether the case should be anonymized for the purposes of publication. And she decided that there wasn't anything of sensitivity requiring anonymization, other than by agreement of the parties, the identity of leading counsel who had succumbed to COVID. And that is quite significant, I think. I mean, it's a minor point, but it is worth bearing in mind that I think the judges are quite alive to the potential consequences. And as I'll mention in a moment, this leading counsel's doctor had advised him or her to take several months off work, and it's probably not the kind of thing which that person would have appreciated being publicized in a commercial court judgment. So I think there was a degree of sensible compromise in that regard, and as I've said, the parties in fact agreed that point, although they were disagreed about other issues of anonymization. Coming back to our particular decision, on the facts, Mrs. Justice Mulder looked at the following. The respondent knew by the 25th of January of the difficulty that leading counsel had, and had it got its act together at that stage, if it really took the view that leading counsel had to be instructed, there was time to instruct someone else for a hearing commencing on the 1st of March. Junior counsel had been instructed, as well as a highly qualified team from an international law firm, including a senior partner who had considerable experience as counsel in international arbitration. And bearing those things in mind, the submission before her was as follows. That the leading counsel in question had been instructed from a very early stage, knew the case inside out with detailed knowledge. And on the other hand, there was no serious countervailing prejudice that the other side would experience by a modest 2-month adjournment of the type that was sought. And so the allegation before her, which she had to decide, was that this was a breach of the tribunal section 33 duty, which is the general duty of fairness, which is referred back to in section 68(2)(a), which is the subject of the challenge. failure to adopt procedures suitable to the circumstances of the case. That was the submission. But she said no. As I've mentioned already, there was knowledge by the 25th of January that this issue was in the arena, and at that stage, there was time to find somebody else. She also took into account the fact that the other team members were able effectively to substitute the work between themselves. And she took into account also the fact that the particular contract, the arbitration agreement that gave the tribunal jurisdiction itself, mentioned the general desire of the parties to deal with any disputes expeditiously which arose. Hope I've got enough battery power. And the tribunal, having indicated at an earlier stage that it was generally not minded to adjourn, because there were other issues which were raised as well, the respondent, in Mrs. Justice Mulder's view, should not have been surprised that the tribunal didn't adjourn. Highly qualified team, time to get another leading counsel if that was really necessary, and although it wasn't done in the event, the other team members were able to step up to the plate. In terms of how the commercial court, of how Mrs. Justice Mulder dealt with the decision, I don't think there's really any surprise here. It's, one might say, the typical sort of Section 68 point, which an aggrieved arbitration party tries to run and inevitably fails on. But there is an interesting footnote here. This didn't arise in a maritime context. It was institutional arbitration. And there was, in this particular type of case, and given the firms involved, much more of a tradition of solicitors conducting the advocacy in the arbitration. I wonder, had this been an LMAA case where there isn't the same tradition of solicitors doing advocacy and a more regular and general reliance upon the traditional pattern of briefing barristers, I wonder if an LMAA tribunal on these same sorts of facts would have reached the same decision in relation to the adjournment. I think whatever decision they had reached, or they might have reached in this hypothetical, would have been upheld by the commercial court. That's not the point, but I wonder if their decision in the tribunal would have been the same. I'm not aware of any LMAA cases of the same type which have given rise to a challenge in court yet, but we shall see. Let me then move on to arbitration 4 of 22. This was an NYPE trip time charter. Carriage of coal from Indonesia to China. You can see where this is going, can't you? And really, when I read this judgment at the time and read it again for preparation for today, I couldn't help but think this was a really startling example of how logic can sometimes be thrown out of the window and entrenched emotions and end up taking you to a place you really don't want to be. So what happened was discharge port in China, 3 pilots boarded at the pilot station. The third officer had a contactless infrared thermometer, the usual uses for which apparently were measuring the surface temperature of objects, food perhaps for preparation. It's not the kind of instrument which is primarily designed for taking human temperatures. Nevertheless, he used this on the 3 pilots, and the readings apparently were in excess of 37.5 degrees Celsius. In light of which, the master asked the pilots to have their temperatures measured with a traditional, the LMLN report says mercury thermometer. I'm not sure anyone would want to put mercury in their mouths anymore, but that's what we're told happened. Lo and behold, the pilots refused and disembarked. This all happened within about 10 minutes. No chance of them sticking a bulb of mercury in their mouths. The pilotage company then said, well, the master should simply have relied on the fact that temperature readings were taken at the pilot station before embarkation. Although there is a note there, it's not clear from the report at what stage that information was actually passed on, and indeed whether it was passed on before the event. But in any event, the pilot company then refused to send further pilots on board until the owners issued a formal apology for the master's actions. Who'd have thought? So anyway, what happened was There was a lot of toing and froing, and this ended up as a 9-day off-hire claim because as a result of the pilot's actions, the vessel missed her opportunity to berth and so had to wait for the next opportunity to come up. So it was a not insubstantial dispute financially. And you can read the report, it's in the Lloyd's Maritime newsletter. The tribunal was very plainly unimpressed by the conduct of the various parties. You can see the quote I've put up there. But where did liability lie? Well, two issues were raised. Firstly, Charterer said the vessel is off hire under clause 15. This is a default of officers and a putting back. There was also another clause which referred to putting back in a slightly different context, which was raised. And alternatively, Charterer said breach of clause 8, owners have refused to follow our lawful instructions in relation to employment of vessels by failing to allow the pilots to remain on and navigate the vessel. The owners, on the other hand, said, no, master has behaved in a reasonable manner, overriding responsibility to ensure the security of the vessel and safety, Hill Harmony type points. And they said further it was reasonable to insist on checks like this. They submitted that China at the time was the epicenter of the COVID-19 pandemic, and temperature was a primary symptom, at least of those early strains. There was no putting back as well, the owners said, because the vessel didn't go back. She physically stayed exactly where she was. And so where's the putting back they submitted, which is an interesting one. And they said the vessel clearly was at all times able to perform, so no problem here. Interestingly enough, the tribunal found the clause 15 claim very difficult. They did mull over the point about whether this was truly a putting back, because the vessel didn't go back anywhere. She was simply stuck where she was. But the tribunal said, had we been obliged to do so, we would have concluded the vessel was off hire. And they did make the point, and this surely must be right, that it would be very peculiar if your off hire analysis under clause 15 depended upon a physical movement away from where you were, as opposed to just a mere failure to move forward. The reason they weren't obliged to reach a final view was that they said, well, in any case, this is clearly a breach of clause 8. Failure to follow legitimate orders and directions. They said the owners didn't have any right unilaterally to implement a policy of this kind. The tribunal said that there was no right under clause 8. There wasn't a right under clause 8 to fail to follow these orders, and the implementation of this unilateral policy without even discussing or agreeing it with the charterers in advance was a breach of clause 8. The tribunal, interestingly, I think they were alive to the fact that this was one of the earlier decisions on these types of issues, which were going to arise in many similar arbitrations. They were satisfied that the owners genuinely held a concern, but what they said was that they went about dealing with it in a crude and ineffective way, to use the tribunal's language. And in particular, there was no attempt to check in advance whether the pilots would be tested before embarking. That they thought was quite significant. And there was no forewarning of the pilots of any intention to take a temperature reading on board the vessel. They were also critical in relation to the use of the infrared thermometer, which was not designed to take temperature readings of this type. They were critical of the pilotage company. This is interesting. And they said, well, the pilotage company could have done more to have explained that readings had been taken in advance, so that before the pilots embarked, that they were given the all clear. Like I said, it's not entirely clear from the report whether that information was in fact passed on to the owners or not. It seems that it wasn't. Instead, in the words of the tribunal, the pilotage company adopted an unhelpful and contrary attitude. But, of course, this was not the charterer's fault. And In those circumstances, the claim for breach of Clause 8 was made out. I'm going to move on to my final example, and hopefully the slides will be resurrected shortly. This is a case called the Shagang Giant. Not an IOCD type clause, but I think it does illustrate the sorts of commercial difficulties which Natalia mentioned earlier on in her presentation. This was a dispute arising out of an MOA for the sale of the Shagang Giant, which was a very large ore carrier. It looks from the facts in the judgment that there was nothing untoward about this sale, which was for scrapping at Alang. The vessel was apparently built in 1993, and so scrapping in 2020 meant that she'd seen a good 27 years of service. But I don't think the fact of the scrapping had anything to do with the pandemic. But Alang, India, and as we all know, perhaps second only to China, India had some of the strictest restrictions during at least the early stages of the pandemic anywhere in the world, and that did give rise to some problems. There were very conventional type provisions in the MOA relating to delivery location, which mentioned outer anchorage Alang. Just have that phrase in your mind, please. There were conventional provisions in relation to delivery notices. But, and this is of interest for our present purposes, there was a force majeure provision in this contract, clause 10, which said, force majeure, should the seller be unable to transfer title to the vessel, or should the buyer be unable to accept transfer of the vessel, both in accordance with this contract due to, and then there was a list of the usual sorts of provisions, one of which was restraints of governments, princes, rulers, or people of any nation. And it's the restraint of governments wording which became significant later on. Now, there were a number of aspects of this dispute before Mr. Justice Butcher, and only one of them related to the force majeure issue, which I'm going to look at now. The judgment as a whole is actually quite long because there are other issues about where the ship needed to be in order to give a delivery notice and other such things. Now, the Shagang Giant arrived in Indian waters in the middle of March 2020. That was fine, but she couldn't reach outer anchorage Alang because the Indian authorities had at the time prohibited ships from entering this particular area, which was the Gulf of Cumberland, without obtaining a special clearance. This was just one of a number of COVID-19 related lockdown measures in force in India at the time. There were also provisions which are relevant in a document called the Indian Shipbreaking Code, which required a number of things to happen. One was a desk review that it seems was just a purely administrative review of various documents submitted. If the desk review was passed, then the relevant authority would take a decision about allowing the ship to anchor. And if the ship was allowed to anchor, she would then be boarded, permission to beach would be given, and the vessel would be beached. Now, the special clearance was in fact duly obtained, but then for reasons which never became apparent, at least from the judgment, the Gulf of Cumberland Vessel Traffic Service, VTS, said, to stay outside the VTS area without giving any reason or explanation, as I've mentioned. So although the clearance was obtained, she still couldn't get to outer anchorage Alang as required by the delivery provisions. So the sellers then contended that delivery had taken place. The buyer said delivery had not taken place. There was a bit of an impasse. The authorities continued to be petitioned during this time. And the chronology then moved to the 24th of March. And the Shagang Giant was still outside the Gulf of Cumberland VTS area when the Ministry of Home Affairs of the Government of India said, nope, that's it, lockdown for 21 days. And this was quite strict. The offices of central and local government should be closed with certain exemptions. That was the wording of this particular measure. And there was no dispute on the facts that all ship recycling, ship breaking activity at Alang was entirely suspended during this time. Communications continued, nothing improved. And then the next development was on the 14th of April. You might remember this, the Prime Minister of India addressed the nation and said that the lockdown, which had been arranged, would continue until the 3rd of May. And, quote, all restrictions that have been imposed in various sectors and on various activities will continue to remain in force. And that was then given force of law. So we can see on the next slide, the buyers at this stage had enough and they terminated. And this was the wording you can read for yourselves, which they gave by their termination notice. It won't surprise you to hear that the sellers disputed the ability to terminate. They said, no, we are regarding this as a purported termination, which is a repudiation, and we are accepting it as bringing the contract to an end, and we are taking the Shagang giant away from Indian waters. It's interesting. I'm not sure if that was because they didn't think there was any prospect of the situation improving. And if you read the judgment, they actually ended up selling the vessel for a significantly lower price for, in the end, shipbreaking in a different part of Gujarat. So I'm not sure how this all happened exactly. But anyway, that was the seller's response. If we can go to the next slide. So, and the next one. The legal proceedings, which were issued in the commercial court here as a result of the exclusive jurisdiction provisions in the MOA, both parties had claims against each other. Buyers wanted return of their initial deposit, sellers wanted to keep that and sought damages for repudiation. And a number of issues arose, and the judgment is quite intricate. If you're interested, please go away and read it, because it does give some excellent guidance as to the sorts of issues which can arise and their interrelation. The first two issues related to what was necessary to give a proper construction or proper transfer of title on a proper construction of these provisions. Did it require delivery? And if so, delivery at a particular place? Mr. Justice Butcher answered those questions in the negative. So strictly speaking, his decision on the force majeure point, which we're looking at now, is obiter, but nevertheless of some interest, I think. And ultimately, he held that the buyers would not have been entitled to terminate under clause 10. And he said, well, you've got to look firstly at why the Shagang giant had not been delivered at outer anchorage Alang by the 14th of April, and what was preventing such delivery. And secondly, if the MOA had not been terminated, i.e. the counterfactual, what would have actually happened? And he deliberated on some considerable evidence. This was a 7-day hearing with a lot of factual evidence and expert evidence, which I think was in writing only. But on this slide, we can see what his answers were. He said that the relevant officials had been ordered to work on other more important matters, which included liaising with local hospitals and dealing with blood supplies and such things. I mean, pretty important things compared to a delay in shipbreaking. But as a result of that, the desk review hadn't been carried out. And so the other things, boarding, permission to beach, beaching, etc., hadn't happened. And secondly, he said that had the MOA not been terminated, the likelihood on the evidence was that the desk review could and would have taken place by early May. That would have been carried out, the relevant authorizations would have been given, the vessel would have been able to proceed to outer anchorage Alang, and everything else would have followed. And he thought certainly in the first part of May of 2020, everything would have been fine. So the question was, as we can see, whether this could give rise to an inability to perform by reason of a temporary restraint of governments. Well, he said that depends upon whether the probable period of restraint was such as to undermine the commercial adventure. And he specifically said the considerations which arise are similar to, although it's a distinct concept, similar to the question of whether a contract is frustrated or not. And we can see on the next slide that he decided no. This was an intended demolition. This was significant, not trading, right? And the contemplated duration of the demolition process was a year. And in fact, he took account of the fact that there were only 2 tides a month, which were sufficiently high to beach this vessel. So it was inherent in the nature of a contract like this. If you happen to miss one high tide, you'd be waiting 14 days for the next one. So in the context of that kind of thing, demolition, not trading, long protracted demolition process, got to wait only 2 opportunities a month to beach her anyway. The limited lockdown, which as of the 14th of April, when the termination happened, would not have extended beyond the 3rd of May. And for all those reasons, he held that such delays did not constitute an inability on the part of buyers to perform the purposes of Clause 10 because they did not materially undermine the commercial adventure. So as I've said, not an IOCD type case, but one which gave rise to these sorts of force majeure considerations and arguments, which could well arise in the context which we've been looking at today. That really concludes my presentation. So thank you very much. And I'll hand over back to the chair.
Thank you, Ravi. So I don't know, do we have time for Q&A? And I cannot see the questions because they're on the computer. So does anyone in the audience have any questions? Okay. Hey, the microphone.
Hi. So one of the issues that we had arise quite a lot during the COVID pandemic is basically charter parties concluded while the pandemic was going on. And then shortly after the charter party was concluded, COVID cases rise in one of the ports where charterers want the vessel to go. Owners say, we don't want to go to that port. And charterers say, well, no, you concluded the charter party after COVID had already happened. You've accepted the risk of COVID in these particular ports. So you can't rely on the old clause D, I think, in the BIMCO clause to turn back. And the solution prior to the 2020 clause was in Paiwan Wisdom / Product Star. And that basically said, if owners have concluded like a normal worldwide trade charter party, they haven't accepted the risk of COVID as it was at the conclusion of the charter. But if owners have concluded a charter party with the intention to go to some place in particular, then they've accepted the risk of COVID at that particular place as of the date of conclusion. So in that latter case, owners would have to prove there was a material increase or a significant increase in the risk of COVID. And just looking at the BIMCO, the new BIMCO clause, it says that risk of exposure means a risk of exposure to a disease which arises or substantially increases at a port or place, whether such a risk existed at the time of entering into this charter party. So my question was, is the intention of the clause to sort of reverse the Paiwan Wisdom Product Star general position, where the default for a worldwide charter is you don't accept the risk as of the date of conclusion, but the position for a charter with a specific intention to go somewhere is you do accept the risk at those ports. So is the intention of the new clause to sort of make owners accept the risk of COVID / any other pandemic as of the date of conclusion, where they've got a worldwide charter? Does that make sense? Mm-hmm. Okay.
So you can. So this is, first of all, it's really, really important to note that this subclause D you're referring to should just apply in the extreme circumstances. So that's the last resort only. And this is the bit we took from the epidemics clause before. So that means like it has to be an increase. If COVID is everywhere, you cannot really rely on this. And
Yeah, there also has to be, that it does subsequently follow with the exposure risk notice, that there is the burden of proof that there has been an increase in the situation from when they fixed, as it is kind of practically as well when we deal with piracy.
Yeah, and that applies for worldwide charter parties as well as, yes, okay, brilliant.
I was also going to say, also in the case where owners don't ask for new orders, but there's just, she's delayed anyway under little b, no, under C, if in connection with the disease, the vessel's quarantined, refused submission or otherwise delayed, then it's the time she remains on hire and expenses of a charter's account, unless charters can prove that that delay or refused admission is due to a pre-charter party risk or problem, say with the crew or whatever it is. So you've got that division as well. Even when she doesn't go to a new port, that's how we've split the division of liability. Whether parties will strike that line out, I don't know, because of course, if you strike that line out about whether it exists at the time or not, then that completely changes. Potentially, you then bring in all those arguments, as you said, under case law. This is going to be a difficult question, Robert.
It's going to be two questions. One for Ravi about risk exposure notices, where you said that the fact that one needed to produce evidence indicated that one needed to behave reasonably. And I was wondering just what sort of reasonably this was in terms of a contrast between having a reasonable thought process at the time, as it were, what one might say in other contexts, on reasonable grounds, as against what Tyr did in the Triton Lark in relation to Con wartime, which is it reasonable in terms of the facts, whether or not you had them in your head at the time? You, Ravi, seem to me to be saying the first, reasonable grounds, and the explanatory note seems to be saying the second. But there's also a larger question, if I might, about the clause as a whole, which is, it seems to be actually accepted that there aren't going to be corresponding provisions in voyage charters. It's commercially unacceptable to try to do that. But the clause still uses, forgive me if I say, the old formula, that it all has to be incorporated down the line, even though you know this is never going to happen in the real world. And wouldn't it be better to try to put a provision in the clause to deal with the situation down the line that might actually correspond with reality?
What would you suggest, Robert?
How do you want to achieve that? This is like a really nice one, then you are like on the hook forever. This is because we thought about it a lot, especially this incorporation provision. And we know from practice, I worked for a long time in-house. If you, the charterers and the guys in the chartering department cross it out, this incorporation provision, because they say no one is ever doing this. But we have the insurance problems then on the other side. So you're really describing one of the main issues we had and one of the main difficulties we had to overcome. And we thought about it for a very long time, how we can address that we have this theoretical approach, which no one does in the practice, but we cannot just let it out because we have to deal with the insurability of the clauses. We at BIMCO, we cannot create insurance gaps. So the actual thing, what we thought would happen in practice is before people do these accept alternative voyage orders and go somewhere, they reach out to their clubs and then they would arrange for the insurance. So it would most likely not be a problem in practice. So this is a bit, but you're really directly pointing to one of our problems.
Can I answer a moment? You asked me how I would do it. Now, I have not thought about it in detail to draft it, but where I'd probably go if I had to draft it would be to say the bills of lading almost certainly don't say she's to go to port X. They say she's to go to port X or as near thereto as she can safely get. So what I might do in the clause when I was dealing with risk exposure notices would be to put it in terms of the master's opinion as to whether she can safely get into the port. And then it would tie in with something that, with any luck, is actually there in the bills. Now, I'm not suggesting in any way, shape, or form that that's foolproof. You can't put it into a clause and then sue me if it doesn't work. But it is a direction in which I might have tried to go because it relies on something that's there in the bills. And if you'll excuse me, I want Ravi's answer to my question about reasonableness.
I do want to make a point that we did actually bring up the concept of the safety provision several times, and we decided against it because it can actually end up, how to say, tampering with other provisions in the charter parties. So it actually was thought through.
Yeah, thank you, Robert. I think the answer to your question is it is a sort of Triton Lark analysis for two reasons, not just because the committee in the explanatory notes say that's what they were trying to achieve, but I think that's what they have achieved if you look at the wording. The exposure risk notice itself doesn't make any reference to reasonableness. The word reasonable appears in clause D, where it says the vessel shall not be obliged to proceed to or continue to or remain at a place where in the owner's reasonable judgment there is a high risk from a disease which cannot be prevented by taking preventative measures, and they have to have given the charterers an exposure risk notice in order to avail themselves of this. I think looked at as a whole, that imports two concepts. One, plainly, there's a matter of construction. The owner's judgment has to have been reached in good faith. And I don't think anyone could seriously argue against that. But in relation to reasonable judgment, that does, to my mind, import an objective standard. They have to make their inquiries. They have to look at the risks, and they have to make their notice referable to the supporting evidence which they have concluded and obtained. So I think it is an objective standard. Obviously, good faith is part of that, but it's got to have been objectively reasonable. Where the issue may arise, and Nina, I think you alluded to this, or Nicola, you alluded to it, I think, is what happens if you have scant evidence at the time. And by the time you get into your arbitration 18 months or 2 years down the line, it turns out that the picture has changed. I suspect the answer to that, which most LMAA arbitrators would give you, is as follows. They would say, well, we can't look at hindsight for something like this. We've got to look at what reasonably would have been available to a hypothetical reasonable owner at the time, and what inquiries should he have reasonably made. If it turns out that his decision was correct, but based upon insufficient material, i.e. factually they got to the right conclusion, but they didn't really have sufficient evidence to back it up, I don't think that changes matters, because even if you say there's some kind of breach there, it hasn't caused anything, because your counterfactual, but for the breach, would simply have been a greater inquiry and the same decision at the end of the day. Where it will be interesting is if the decision is made on insufficient evidence, and had the inquiry been made properly, the decision would have been different. I think in those circumstances, the owners are going to be in difficulties. And commercially, I don't think there's anything wrong with that. If there is information which they could reasonably have availed themselves of, but failed to make the relevant inquiries, that frankly is their problem. And I don't think that's an unfair solution.
Yeah, and this is how we drafted the clause. And this was what our thinking behind it is, because this is like a very strong right the owners have, and it has like significant and severe consequences on all underlying contracts and the sales contracts. So it should be that the owners, before taking that decision, do like take reasonable steps and do reasonable inquiries. So it's not enough that they say we have some people heard like there is an issue, because this is the last step to disrupt the trade.
I also want to say that this was primarily brought up from our side as well, because this is the exact step-by-step procedure that we enforce both on our ships and on ownerships when entering piracy areas. Because you again have to have factual evidence, factual-based evidence, even if the JWC increases the high risk in certain areas as they did a couple of months ago, about a year ago, and we had a lot of owners push back against it, especially owners that we had on long-term period. We still asked them, you have to show us factual-based evidence on this, and in most of the cases, they had to proceed because it wasn't enough evidence that much had changed. There was no change, as you had mentioned before, to the original entrance into the charter party.
Do you think there is any scope for subclause C to be construed as the charterers can be liable for the so-called blood money if a crew member dies as a result of contracting the disease due to ports called at the charterers' orders? Or I mean, by saying blood money, it could be disability or medical expenses or something like that. Thank you.
I think in that scenario, it probably would be a direct loss, damage, or expenses incurred. So yeah, potentially it would come within the clause as a charter's responsibility. From my side, the only query I've got on C is if in connection with a disease, anything kind of theoretically could be in connection with a disease. I think you're going to have arguments that it doesn't, obviously we didn't want to say if it's caused by the disease. That is an area of ambiguity where I can see that arguments could be made on both sides.
Do we have more questions? So we have nothing in the chat. I think it's pretty late. Shall we just call it a day? Great. Then thank you everyone for coming. So we have drinks. Thanks to Ravi, and have a nice evening. Thank you.